Please take your seats. Good morning, Mr. Hardiel. You will call the case.
Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana, CCJ application number 9 of 2018 between Arnold Sankar and the Guyana Rice Development Board. The hearing of the application for special leave to appeal is on this morning. Can we have the appearances for the court, please? Thank you.
May it please your Honours, I appear for Arnold Sankar, and appearing with me is Mr. Rajendra Jaigobin.
If it please your Honours, I appear for the respondent.
Thank you. I think we allowed both parties 45 minutes each to make the oral submissions. There are a lot of facts in this case that we have noted. It would seem that the parties are in agreement about most of these facts, if not all, although they give a different spin on some of them. Is that correct, Mr.
I think so, sir. I think so, Your Honours.
Yes. Okay. Well, we have kind of listed these facts. I'm not going to spend time to mention them, but we have everything from the 7th of November 2016 to the 6th of February 2019, so that you can be assured that we have those facts clearly before us. So, Mr. Nandwell, it's up to you now to start your submissions.
Your Honour, do I stand or do I sit? I'm not sure.
Well,
Yes, you sit, we hear him better.
if you sit, we hear you better, and I think that's more important.
Thank you very much, Your
We
Honour.
know how you look like, how you stand.
Your Honours, our submissions are quite elaborate, and
Yes.
they are on record, and we are relying on those submissions. Perhaps in my oral presentation, the convenient point to begin is to examine the order which was granted by the Court of Appeal against which we have sought this special leave to appeal. That order, Your Honours, can be found at page 293 of the record. And the reliefs which were granted are as follows. A, an order that an extension of time be granted to the applicant to seek leave to appeal the decision of the full court. Your Honours, I pause there to make my first submissions. My first submission. I have examined the rules of the Court of Appeal, Your Honours, and I can find no provision in the rules which grant to the Court of Appeal a power to extend time to seek leave. Your Honours, I wish to respectfully draw Your Honours' attention to Order 2, Rule 2, which reads, where an appeal lies by leave only, any person desiring leave shall apply for leave within 14 days, either by notice of motion or by summons, etc. Now, nowhere else in the rules empower an extension of time to be granted in relation to this provision which allows for leave to appeal. I respectfully submit that the rationale for, first of all, I respectfully submit that that omission is deliberate because, Your Honors, where leave is sought, you would have had a High Court judge adjudicating and two other judges of the High Court constituting the full court adjudicating, and that is why there is a requirement for leave, which essentially, as this honorable court has described it, is like an act of grace. And I believe that the framers of the rules have granted 14 days for that exercise of discretion, and they did not see it fit to extend it beyond that. I recall, Your Honors, in the case of Malweg Darnley and the Joy Reid and Anthony Reid, Millard Hayton, I believe, drew a distinction at paragraph 11 between appeal as of right and appeal via the discretionary route. This appeal, Your Honor, falls into that discretionary route. If I am to refer to the learned, the judgment of the Court of Appeal rendered by the Honorable Madam Justice Dawn Gregory, Her Honor seemed to have predicated the exercise of her discretion to extend this time upon Order 2, Rule 4. And I have difficulty in understanding how Order 2, Rule 4 is applicable, because Order 2, Rule 4, and I'm using various permutations in trying to understand which rule Her Honor may have been referring to. If we go by Order 2, Rule 4, in the numerical setting out of the rules, it deals with service of a notice of appeal. So that one can't be relevant. I then examined Order 2, Rule 2.4, that deals with if on the hearing of a motion brought under this rule, the respondent is giving leave, that one is not applicable. So I am going on Order 2, Rule 3.4, and that one may be the one that the Court of Appeal may have, of course, inaccurately, may have invoked. But that, Your Honor, when one reads it from the beginning, it deals with time limit for appeals. This deals with where you have a right of appeal, and you may have not filed your appeal within the time, and you are seeking an extension of time within which to file the appeal. So the orders upon which the Court of Appeal relied to confer itself with a power to extend time to grant leave to appeal is absolutely not applicable.
But Mr. Nandlal, what about Order 1, Rule 8? Is that not available?
Your Honors,
Have you got it, or shall I read it
I
out?
would like to make, Your Honors, is that the Court of Appeal did not rely on Order 1, Rule 8. That's the first observation.
It did not expressly rely upon that, but it is part of the background jurisdiction that they have, is it not? They can direct a departure from these rules where this is required in the interest of justice, and they may enlarge the time prescribed by these rules for the doing of anything to which these rules apply. So it would appear they had jurisdiction under Order 1, Rule 8.
Your Honors, whenever Order 1, Rule 8 is invoked, it is normally expressly mentioned in the invocation, as Chancellor Haynes did in the case of Hing and Hing, which I have referred to in our submissions. You will see in that case, Your Honors, that Chancellor Haynes dedicated a substantial part of his judgment in relation to Order 1, Rule 8 and how the jurisdiction should be exercised. But here, clearly, the Court of Appeal was not invoking Order 1, Rule 8, and we ought not to speculate because the Court of Appeal identified the rule that they have relied upon, and I say with the greatest of respect that that rule was not the proper rule.
But the question was, as you put it, did the Court of Appeal have the power to enlarge the time to allow an application for leave? And as Justice Hayton indicated, it would appear that they had that power under Order 1.8. Now that they didn't invoke it is a different thing.
Your Honors, it is my respectful submission that if the framers of the rule wanted to confer such a power on the court to grant a further grace, because they have given 14 days to approach the court, if they wanted to confer a power to grant a further extension, they would have done so expressly and not by implication. Because if one goes under Order 1, Rule 8, it is by implication. Your Honors, I ask the court to compare the elaborate mechanism that has been laid down in the rules to grant an extension of time in relation to where the appeal lies as of right. And you see how that is set out in Order 2, Rule 3, the procedure, the time, exceptional circumstances, etc. And if one is to compare that elaborate mechanism with Order 2, Rule 2, which grants that 14 days and says nothing more, then I respectfully submit that the clear inference to draw, and I invite this honorable court to do so, is to draw the inference that the framers of the Constitution the framers of the rule did not intend to confer a discretion upon a discretion. That, in other words, that they wanted to give 14 days, and if that 14 days expires, well then that is the end of the matter. I believe, Your Honor, respectfully, that Order 1, Rule 8 should be used in the most exceptional of circumstances, as Chancellor Haynes adumbrated in Hing and Hing, and many of our judges in the Court of Appeal of that era adumbrated, giving the rationale, and they all admonish that Order 1, Rule 8 should only be resort to when there is a clear case of injustice and when the departure from the rules would address a clear case of a miscarriage of justice. And I am respectfully submitting, Your Honor, that such a case is not made out here, having regard to the history of this matter, a history and a litany of errors and mistakes made by the respondent, and I'm going to get into that at a later stage. But permit me, Your Honors, to move on a little to deal with the second aspect of the rule.
Mr. Nanda, just before you
by
go
the
there,
Court of Appeal.
Mr. Nanda, before you go there, just to be clear, so you are not saying Order 1, Rule 8 can never be applied in a case where you seek leave to appeal, but it can be applied, but only in very exceptional circumstances, when there is a clear miscarriage of justice, and that is not the case. Is that your submission?
I am comfortable with that formulation, Your Honor.
Okay, great.
Thank you very much, Your Honor. Your Honors, if I move to relief letter B, that reads that leave be granted to the applicant to appeal the decision of the full court of the Supreme Court of Judicature. I pause here, Your Honors, to say that at the time when the Court of Appeal granted this order, the respondent GRDB was some nearly 6 months out of time for the appeal to be filed. And therefore, this order does not qualify. It does not qualify the respondent without more to file that appeal, because an extension of time is required pursuant to Order 2, Rule 3 for that appeal to be filed. So granting leave was only one of the requirements. An extension of time also had to have been granted within which to file the notice of appeal, because the time prescribed or delimited for the filing of a notice of appeal had expired by months. And therefore, the Court of Appeal order itself, again, I submit respectfully, is defective and could not have given the applicant in its current formulation, could not have given GRDB, pardon me because I don't know, yes, the applicant in the case, the requisite authority to file the appeal. And Your Honors, if one examines the Court of Appeal reasoning again, one sees that the judge, the Honorable Madam Justice Gregory, went straight to deal with order. Again, it's difficult to understand which order, but I am assuming that Her Honor was referring to Order 2, Rule 3, 4, and 5. Order 2, Rule 3, bracket 4, and 5. But that, Your Honor, deals with an extension of time within which to appeal. And the applicant never sought such an extension of time within which to appeal. And none was granted. None was granted. What was granted was simply that the applicant be granted leave to appeal. And pursuant to this, the applicant has filed a notice of appeal without getting the requisite extension of time, which, Your Honor, is a prerequisite for the grant of leave. And this is the order. We ought not to go beyond the order, and this is the reasons for the granting of the order. So, Your Honors, having made those observations in a preliminary fashion, I now wish to move on to our application itself. Your Honors, as I had mentioned before, what you have here, when one examines the record of appeal, one sees on the one hand a litany and concatenation of tardiness and errors on the part of one litigant, and on the other hand, one finds a litigant who has committed no error, has scrupulously followed the rules of court and procedures all the way up and prosecuted his cause with admirable vigilance and diligence, and at the end, at the apex court, meaning the Court of Appeal, got nothing as a result. And at the end of the process, that delinquent litigant was awarded the prize. And that is the simple story of how the record reads. And Your Honors, the recitation of events are contained in the affidavits as well as in our submissions. There was a default from the time the matter was filed, because under the rules, the affidavit of defense was supposed to have been filed 11 o'clock of the forenoon before the matter was heard. So you had the first default from day one. And then leave was granted, and then that was not observed, and then an extension of time was given, and there were long extensions. I ask Your Honor to pay attention respectfully to the length of time that was given on each time that applicant was granted, the GRDB was granted an indulgence at every step of the way. And then, Your Honors, the unless order was made. And of course, my learned friend is contesting whether it is an unless order or not. The truth of the matter is, our courts have always been treating that provision and the exercise of power under that particular rule as an unless order. The applicant did everything that the applicant could have done, entered the order, solved it on the other side, but we could not have obtained the judgment because that is how the rules are structured. Unlike in other jurisdictions, you take the unless order and you get judgment instantaneously based upon the unless order itself. In Guyana, unfortunately, the practice is that one has to go by way of a summons, as the applicant did, as a demonstration or another demonstration of his diligence and vigilance, and then was met with a counter summons seeking an extension of time, etc. And then the Honorable Justice Insalali felt that Her Honor had the power to act against her own unless order and then granted leave. And of course that took us to the full court, and we respectfully believe that the full court restated the position firmly and restated the force, validity, purport, nature, and effect of an unless order. And Your Honors, this court, I know in particular, I've read some of the judgments given by this court and in different incarnations, and I am aware that this court is fully experienced and has made some very strong admonitions in relation to the new dispensation that the CPR brings and the movement away from the laissez-faire approach that has caused us and our legal system so much problem in the past, and the need now for us to have litigation that is driven by urgency, driven by rules, and the rules must be seriously obeyed. This is a classic case of neglect, right up to the Court of Appeal. And then we come to the Court of Appeal, Your Honor. That 14 days, the leave to appeal came way beyond the 14 days. How many? The first time they came to the Court of Appeal. It came several months. And then, Your Honor, in the Court of Appeal itself, there was a multiplicity of applications made. The first one was made and then withdrawn. The second one was served on us. We came to the chamber judge of the Court of Appeal, voiced our objection that it's before the wrong court. It was withdrawn. Then a motion was filed to the full bench, and then we turned up again. That one was dismissed for want of prosecution. And then another motion was filed, and then that eventually yielded success. So how do one weigh the scale of justice in this procedural journey that the applicant, Arnold Sankar, has embarked upon from day one? He has done nothing wrong, and he's being deprived of the fruits of his judgment. And all the pronouncements which we have cited to the court, Trincan, Hing and Hing, and all the other cases, the case from Belize, where His Honor Justice Barrow also spoke, they all emphasize the need for litigation to proceed with promptitude, urgency, and diligence, and the days for tardiness are over. The rules of court must be obeyed, litigation must be final, and a litigant must be enjoyed. A judgment creditor, must be allowed to enjoy the fruits of his judgment, and there must be finality to litigation. All those principles, Your Honor, adumbrated by this honorable court over and over again, we are relying upon, and we say that this court, as the apex of the Guyana judiciary, should set its face firm against the tardiness which is patent on the record here, and to also give us some guidance in relation to how we should approach leave to appeal, and more fundamentally, unless orders. Because one of the grounds upon which the Court of Appeal wanted, and we made that point in our submission, that the Court of Appeal seemed more concerned, for want of a better word, and I say this with the greatest of respect, with wanting to give guidance rather than do justice between the parties. And ultimately, a court of law is to do justice between the parties that are before it. Everything else is ancillary. But guidance can come from this honorable court on these procedural issues, which I concede are of some moment, and this court, if it decides to accept my invitation respectfully and give the guidance, it would do well in terms of the profession and giving the type of directions which are required from this apex court. Your Honors, I believe that those are the important issues that I would like to canvass before this court. And Your Honors, there are two cases which I wish to leave with this honorable court, and they deal with the exercise of discretion when an extension of time is applied for within which to file an appeal. Now, I emphasize that these cases are where there is a right of appeal, and therefore the principles enunciated herein will apply a fortiori in cases where one is seeking leave to appeal and where there is no right to appeal. The first case I wish to rely on, Your Honors, is the case of Noel Fraser against GTM. Guyana, the Law Reports of Guyana, 1991 to 1993, at page 315. In this case, Your Honor, the intended appellant was
You're bringing
out of
these
time.
cases in now, is that so?
Sorry?
These cases you're now mentioning, you have not put them before us yet.
No, please, Your Honor, and I do offer my profound apologies.
And did you speak with counsel for the other party that you were going to present these cases?
No, Your Honor,
You did.
no, I didn't. I didn't.
You are seeking an extension of time within which to rely on them.
Yes, Your Honor. But I'm sure my learned friend is aware of these cases. They are quite popular and well used in Guyana. Your Honor, in this case, the right of appeal had just expired by just a matter of days. The reason given was that the applicant could not have afforded to retain counsel, and even lay out the fact that he sought to sell a television set in order to raise funds to retain counsel. He went to a single judge for leave to appeal. He was only a few days out. That single judge refused on the ground that he did not provide good reason. And then he went to the full bench, as he is entitled to do if he so desires. And the full bench ruled that the affidavit was nebulous and did not give good and substantial reason for the lateness. So they did not upset the Court of Appeal, the single judge's ruling. The other matter, Your Honor, that we wish to refer to is Chandrauti Ramlal. Chandrauti Ramlal.
Can you spell that out, please?
Sorry, it's GTM, Guyana Trinidad Mutual Fire Insurance Company Limited, against Chandrauti Ramlal, Chandrauti et al. And it's in the same report, Your Honor, at page 175.
Could you please repeat the citation?
The law
Yes.
report of Guyana, the law reports of Guyana, 1991 to 1993, page 175.
Okay, can you send those two cases in copy to us?
Yes, Your Honor, before the end of the day.
Good.
Here again, Your Honor, no extension of time was granted, and Chancellor George examined an array of authorities in relation to how the power or discretion in relation to an extension of time should be exercised, and ruled against granting that extension of time. I say so, Your Honor, to say that our courts have always guarded the discretion in relation to extension of time, or in relation to any discretion which the court is possessed of. And as Chancellor Haynes in Hing and Hing explained that one must always look at the interest of the case, and that includes, the interest of both sides. Your Honor, that passage can be found at page 327 of the record, and if I may be permitted to read it. The dominant consideration, and Your Honor, most importantly, Chancellor Haynes was referring to Order 1, Rule 8. The dominant consideration is the interests of justice, and it is for this court to determine in every individual case, as it arises, whether recourse to the rule is demanded. It is neither possible nor desirable to attempt to define or categorize the circumstances which can or will do so. This court's sense of justice must be its guide, but it must be the interest of justice according to law. This consideration includes not only the interest of the dissatisfied litigant who wishes to pursue a right of appeal, but also those of the successful one in the satisfaction of judgment in his favor without undue delay, as well as regard for the important administrative principle against undue protraction of litigation. We have to balance the two competing interests, bearing in mind the third, and in so doing, it is not irrelevant to recognize that a right of appeal is not one to which a litigant is entitled as a matter of natural justice. We are dealing here, Your Honor, with not a right, but a leave matter. And here, His Honor is saying, in so doing, it is not irrelevant to recognize that a right of appeal is not one to which a litigant is entitled as a matter of natural justice. It is a statutory right, exercisable, subject to compliance with the conditions prescribed by the statute or statutory instrument. The litigant who does not comply and so is unable to stand in this court and challenge the judgment of the court below is not thereby deprived of a right to do so. What has happened is that he has not qualified to exercise the right, and a legal bar arises as a result of such non-compliance. To order a departure from a statutory rule is a grave step, far more so perhaps than extending the time for complying with one. Here, Your Honors, we have both. In the latter instance, there is late compliance. In the former, none at all. In modern times, the courts have been regarding obedience to appeal rules and time limits fixed, therefore, as something normally to be insisted upon. In Ratnam and Komarsam, 1964, 3 All England, 1, where the Privy Council upheld the order of the Court of Appeal of the Supreme Court of the Federation of Malaya, refusing to extend time for filing the record of appeal without giving any reason. Lord Guest had this to say, and I quote, "The rules of a court must prima facie be obeyed, and in order to justify a court in extending the time during which some step in procedure requires to be taken, there must be some material upon which the court can exercise its discretion. If the law were otherwise, a party in breach would have had an unqualified right to an extension of time which would defeat the purpose of the rules, and which is to provide a timetable for the conduct of litigation." Your Honor, this was stated over 40 years ago by Chancellor Haynes, and it has lost neither its efficacy or its value notwithstanding the passage of 4 decades. This can apply with equal force now in our setting of the CPR and the whole philosophical underpinning with which it comes, that is to expedite litigation and to bring speed and dispatch and to remove that what Your Honours label as the laissez-faire approach. And the other point that I want to emphasize, Your Honour, is that Arnold Sankar, while the procedural hiccups were taking place and GRDB was trying to sort itself out after these several errors that it has committed, Arnold Sankar has already begun to execute his judgment as he is entitled to do, since there were no orders staying the judgment at any stage of the process. So there has been levy execution, and a number of motor vehicles have already been seized and I believe are in the custody, have been sold, I'm told, have been sold already. So I just would like to put that in the domain of the court so that the court is fully apprised of the facts. Your Honor, having expressed those brief sentiments, I would like respectfully to rely on our submissions, and if there is any assistance that I can humbly render to this court, I am of course ready, able and willing to do so upon Your Honor's request.
Thank you, Mr. Nandlal. Of course, you have reminded us of what Chancellor Haynes said 40 years ago. There's also what the Romans said 2,000 years ago, summum jus summa injuria, or the full application of the law may lead to the greatest injustice. Is there anything in that?
I didn't hear that, Your Honor. I'm sorry.
The Romans had this expression, summum jus summa injuria, or if I translated, the full compliance, the full application of the law may lead to the greatest injustice.
Well, Your Honor, the English system which we have inherited is regarded as the finest creation by mankind in the form of a system of justice. With all its deficiencies, it's all that we have. And we all have to ensure that we make the best use of it.
Okay, well, Mr. Nadal, I thought as you have the Roman-Dutch heritage, you had some sympathy for the Romans, but I take it that you don't think that the full application of the law leads to injustice in this case.
No, Your Honor. No, not at all.
Thank you very much. No further questions. Then we will ask Mr. Jonas to address us.
Thank you very much, sir. Can you hear me adequately, sir?
Yes.
Your Honor, I'll start where my friend ended. He quoted Chancellor Haynes and made the point, which is a good point, that before the court extends time, there must be material upon which it must exercise its discretion. Now, during the course of his submissions, my friend, probably prompted by the court, moved away from his surprising contention that there was absolutely no jurisdiction in the Court of Appeal to extend the time, to acknowledge the existence of Order 1, Rule 8, which, as Your Honor pointed out, allows an extension of time in respect of any time frame set by the rules. Now, Order 1, Rule 8 has two aspects. The cases to which my friend referred dealt with the more extreme aspect, which is to order a departure from the rules. So when Your Honors have regard to Chandro T. Fraser and, I'm sorry, the earlier case, can't remember the name, Your Honor will see that there's a discussion about this extraordinary exercise of complete departure from the rules. But the point must be made that Order 1 Rule 8, and Your Honor's made the point, so I won't belabor it, also deals with the more narrow conservative aspect of a departure, which is that you can extend the time. Now, my friend made a leap of logic, which I respectfully contend he cannot properly make. He made the very technical argument that there also needed to be an application for an extension of time to appeal. So not just that there needed to be an application for an extension of time to seek leave to appeal, but also an extension of time to appeal. And the basis of his argument appeared to be his belief that the 6-week rule applied to appeals of this nature.
Sorry, Mr. Jonas. Mr. Jonas.
Yes, please, sir.
Sorry, before you move on to that second point, you are suggesting that Order 1 Rule 8 would give the Court of Appeal the jurisdiction, but could the Court of Appeal invoke Order 1 Rule 8 without, or could it rely on that without expressly saying so?
Very much so, sir. You see, if arguments before the Court of Appeal turn on whether it has the jurisdiction or not, the Court of Appeal in its ruling may well have to explore the ambit of its jurisdiction under Order 1 Rule 8. I say jurisdiction loosely, please, sir. But if the point didn't arise, if it was assumed at all times that there is this power, but the question is how you exercise the power, then it is very easy to imagine that the Court of Appeal will not belabor the issue as Justice said, as Chancellor Ames did in the Chandrauti and Fraser cases. But the Court of Appeal will, acting on the assumption that it has the power, decide how to exercise that power.
But didn't it? But didn't it perhaps incorrectly state that that it was relying on Order 2 Rule 4? I think is what it said.
Order 3 Rule 4.
Order
3 Rule 4 and paragraph 9 of their judgment.
Which
Yes,
is about
and
criminal
I won't pretend to defend that.
Great.
Yes, without pretending to defend it, we are still left with the question: a court asserts power or jurisdiction under a given rule or order, and you're saying to us that we should regard the court as having power or jurisdiction under something which it didn't consider, that we have to assume that the court intended to exercise its jurisdiction in that respect.
No, sir, I won't ask you to assume that. What I'll ask the court to do is I'll ask this court to decide if the Court of Appeal had the power to do what it did. You see, you hear an appeal from the decision, and you decide if the decision was right. Whether or not you agree with the road by which the court below reached that decision is a different argument. But if this court decides that the court below had jurisdiction to make the order it made, and that the order it made was correct in the circumstances, then if the court faltered in its logical approach to that conclusion, it doesn't change the correctness of the conclusion.
Thank you.
Of course, if we look at Order 1, Rule 8, as that has been interpreted in the past, being something that can be done only in very exceptional circumstances and is required in the interest of justice. So we should find something then in the judgment of the Court of Appeal which allows us to believe that that is what the Court of Appeal had in mind when they extended time, so that it was required in the interest of justice. Is that so?
If this court, Your Honor, if this CCJ finds that the interest of justice requires that the decision of the Court of Appeal is the correct decision, that is what needs to be determined. So this court has the record of what went before, of what my friend describes as a litany of errors. And if this court decides that the decision of the full court was so egregiously wrong that it needs to be corrected, or that the claim at first instance was so obviously defective that it needs to be explored, that the interests of justice require it to be fixed, then I respectfully contend that the Court of Appeal, when it came to the conclusion that it wanted to hear the issues arising, acted in the interest of justice, so as to avoid the miscarriage of justice, which this court has referred to in previous cases. So the question is, on this record, do we see the need to avoid a miscarriage of justice?
Okay.
So you're saying the CCJ has all the powers of the Court of Appeal. So if the Court of Appeal has this power in Order 1, Rule 8, then the CCJ does.
If you please, sir, I think we agreed on this a week ago, and I don't think it calls for further argument at all. Absolutely.
So, Mr. Jonas, are you saying that the factors that the Court of Appeal took into account would not really be the factors that you would ask us to look at here? Because the factor in Order 1, Rule 8, the key and ruling factor is what is in the interests of justice. So you more are looking at what is miscarriage of justice than you are at looking at, as they did, length of delay and reasons for the delay. Or do you think that those matters would also arise? So
I
as we
believe
look
those
at,
matters,
Go
I'm
ahead.
sorry. I believe that those matters also arise, Your Honor. I wouldn't treat it as black and white. There are shades of gray in this. The Court of Appeal, in my respectful view, hit on relevant factors that are to be considered in the exercise of discretion to extend time. But in its written decision, unfortunately, I believe they did not hit on all of the factors that do arise on this record, and in fact arose during the course of arguments before the Court of Appeal. For example, the very important fact that general damages are sought at first instance and are not available by summary procedure and especially endorsed writ. So
Where do you find general damages were sought at first instance?
Your Honor, please allow me to...
I looked 3 times, given your submissions, at the specially endorsed writ and at the orders made in consequence thereof, and I saw not one instance of a claim for general damages, which I found, frankly, remarkable.
They were all particulars of special damage, were they not?
Your Honor, you're quite right. I said general damages, and I should have said pecuniary. But the point is that under Order 4, Rule 6, you are confined to a debt or liquidated damages. And what is sought in this statement of claim is neither. And if you permit me, I will start there.
But with respect, Mr. Jonas, I am wondering how we go down that road. An irregularity in the framing of the writ is what you were saying now, introduces the element of miscarriage of justice?
Your Honor, allow me to start there, please.
Okay.
If I can refer you... I'm sorry, sir.
No, I said okay. Start there.
If I can refer you, please, sir, to page 42 of the record. Your Honor, there's a very good reason that my friend is so adamantly and diligently trying to avoid hearing this case on the merits. The language of the statement of claim may need close consideration, but can I begin, please, at paragraph 4 of page 42? The terms of the agreement, as I understand them, are the last 6 lines. The defendant requested the plaintiff to purchase as much paddy available on the market at a price and promised that they will buy this paddy from the plaintiff at $490 per metric ton. Your Honor, we have an agreement to buy paddy from the plaintiff at 490 United States dollars per ton. That is very simple. Your Honor, as a brief diversion, because we are dealing with Guyana currency, and I know to non-Guyanese it's a bit of a culture shock. If I can refer you to page 44, Your Honors will see under the particulars of special damage, there is an item there called sum recovered from sale to Sea Rice Inc.
Yeah.
And Your Honors will see that there is 205 Guyana dollars to 1 US.
Right.
So, Your Honors, 490 United States dollars per metric ton. If I can refer you then to paragraph 9 at page 43. The plaintiff bought 2,121 metric tons. Your Honors, Guyanese are notoriously bad at maths, and more so their lawyers. Your Honor will discover that in a few weeks. But I will ask you, please, to follow my own maths. 2,121 tons at 490 US dollars a ton is 640,920 United States dollars. If you multiply that by 205 to reach Guyana dollars, you have 131 million odd Guyana dollars. So this contract, which is a simple contract, is that however much paddy you buy, we will pay you 490 US per ton. And therefore, when the plaintiff says he bought 21 tons, he was owed 131 million Guyana dollars. Simple. The plaintiff then says, at paragraph 10, defendant only accepted 813 tons. He refused to accept 1308 tons, paragraph 12. So we have an unnecessary complication here. We then have admissions, please, Your Honors. At paragraph 5, this is page 42 of your record, that the defendant advanced $60 million on this arrangement. So we have a simple contract. 2,121 tons at a total price of $131 million, calculated at 490 US per ton, and an advance of $60 million. Your Honor, to my mind, the maths is very easy. What is owed? I'll ask Your Honors to have regard to the particulars of special damage. And Your Honor, Justice Barrow, I hear you when you say you see particulars of special damage. But with great respect, the fact that they are labeled special damage don't make them so. It falls into whether they fall into the definition that we recognize. And I say that because there are items here that I respectfully contend cannot be treated that way. Now, on our simple contract, we have a starting point of total cost of paddy purchased, 90 million. Value of paddy delivered. Value of paddy not accepted. Had it been accepted, what would have been paid? And we have a magical formula. Your Honor, I'm alarmed for Guyana because the author of this statement of claim is going to be arguing before you in a few weeks. The grand end result of this special damages is an amount owing of $99 million. Now, how is that possible if a total of 21 tons was delivered, valued at 131 million, and 60 million was advanced? How is that conceivably possible? Justice Barrow, you had said that you read the statement of claim and you were not seeing that there may have been something impermissible in the claim. But if on the face of this claim, and I invite the court to make hay of this statement of claim, do the best you can with it, because I have been trying diligently myself. There is no way on a contract for 2,121 tons of paddy at 490 United States dollars with an advance of $60 million, I can owe you $99 million. On the face of this, it is impossible. And therefore, Your Honor, a problem is created, a problem emerges. That problem, yes, Your Honor,
Mr. Paragraph 13 of the statement of claim, and that sum of $58,000.
Yes, Your Honor,
Yes.
thank you. I had forgotten that, and I'm glad you raised it. There are two more points I need to raise. If this was simple, 131 million less the 60 million advance, that would be a liquidated sum or a debt. But what has happened is that this plaintiff took the rice he still had, took the paddy he still had, and he sold it to a third party to cut his losses. And when he sold that to a third party to cut his losses, he recovered $58 million. So, Your Honor, you have a contract for 131 million, you have 60 million advance, and then you have another 60 million that he cut his losses with, selling to a third party. And yet, magically, GRDB still owes him $99 million. This is on the face of his contract. And to go back to the question, please, of special damages and what constitutes a debt or a liquidated demand, I will ask Your Honor to observe that this gentleman decided on his own, paragraph 10 of the statement of claim, to borrow money from a bank, and has decided he's charging the GRDB the interest he had to pay on that loan. So, Your Honor will see there are two items in the so-called special damages. Expenses incurred for storage, which certainly cannot be a debt or liquidated demand, and interest paid to GBTI, that's the bank,
Mr. Jonas,
for...
Counsel,
Yes, sir.
would it not have been the opposite thing, given what you're telling us, to have applied to strike out this statement of claim as an abuse of process?
Your Honor, if I can point the court to the affidavit of defense which was belatedly filed by counsel at the time on record. Counsel at the time on record, in his belated affidavit of defense, takes the point that this claim falls outside of the parameters of Order 4, Rule 6. And to answer your question directly, please, sir, under our old rules, the judge who is confronted with a specially endorsed writ which contains a claim outside of the parameters of Order 4, Rule 6 of a specially endorsed writ has the option, rather than striking out, he may strike out, but he has the option specifically given to him in the rules to treat it as a general writ.
Yes, I know that.
And so the application to strike out, Your Honor, I would not have advised.
What one does as a practitioner is you apply to strike out and leave it to the judge to decide whether to strike or to allow it to proceed in a different fashion. And also, counsel, it would seem to me, given the arithmetical errors, what you say are clear mathematical inconsistencies, it seems to me that that would also be the subject matter of an application to the court, and that would have saved time running, because while there is a strikeout application pending, the fact that documents were with the fraud squad, etc., all of that would become by the way, since what you are looking to do is to strike out this claim.
I have to say two things in response to that, please, sir. First, our experience in Guyana has been, and this is a position that I actually support, that a judge who is faced with a writ of this sort, a writ for pecuniary rather than liquidated damages, is more likely to convert the writ and treat it as a general writ and proceed, rather than to strike it out. So I, in my own practice, have seen very few applications to strike out. What I have seen, what was commonly done, is the position taken in the affidavit of defense that this is not under Order 4, Rule 6, you need to convert this.
Yes,
And that is
Congressman,
what is done
and
in
I
this
think
case.
I'm trying to tell you that as a practitioner, I'm very familiar with that course. It is a natural course, but the mathematical errors to which you point would also be matters that a judge, in hearing such an application, would direct counsel's attention to and say, this is an abuse of process. You cannot have these clearly erroneous figures which are incapable of support, and you need to amend in that regard as well. But I think the short point I'm making is that the respondent, the defendant, had the opportunity of preventing time from running.
Your Honor, you segue into the second response which I was hoping to make. As I had said, there were two responses I wish to make. The first had to do with the culture that has evolved here. The second is that if I were on record at the time, I would very happily have made that observation and tried to throw it out. But I do not believe that GRDB, the litigant, should be penalized for what my friend has correctly described as a litany of errors by counsel. We have a case before you where you have an unsafe judgment handed down by a full court that erroneously treated an order as an unless order and erroneously found there was no jurisdiction in Justice Cincinnati to revisit her order. So you have a judgment that we know is bad in terms of mathematics, and we have a judgment that we know the full court wrongly pronounced upon, ignoring that it was without Order 4, Rule 6, being for pecuniary damages and not a debt or liquidated demand, and erroneously treating it as an unless order, and therefore erroneously finding that Justice Cincinnati had no jurisdiction to revisit it. We have a serious miscarriage of justice, and the interest of justice on the facts of this case, Your Honor, come hell or high water, however we regard the conduct of the litigants at the time, I respectfully feel must be corrected.
Mr. Douglas, there are two other sums that, well, there's one other sum, the expenses for storage. That is 25 million. That is in the
Yes,
statement of claim. And what do you make of that and the interest paid to the Guyana Bank? Are these matters that would fall under such a claim?
Your Honor, I believe that as soon as the plaintiff sold the paddy to cut his losses, and as soon as he started making claims such as the three that Your Honor has pointed out, so the sale to Sea Rice Inc., the expenses incurred as storage, and the interest paid, he is outside of any debt or liquidated demand. He is now making a pecuniary claim for damages for breach of contract, and that is not permissible under Order 4, Rule 6. And Your Honor will note that there is absolutely no discussion in this claim about how $25 million is claimed for storage by a man who's a rice miller and has his own storage facilities. So we have, Your Honor, I wish I was on record at the time, but we have all kinds of problems here. So my friend is right. There is a litany of errors, but it doesn't begin with the affidavit of defense. It begins with this statement of claim. There's a reason that we are in the CCJ arguing a technical procedural point because one party does not want this heard on the merits. If Your Honors agree that this claim falls without Order 4, Rule 6, that we are now speaking about damages for breach of contract rather than a debt or liquidated demand, then, Your Honor, I believe it brings us to the central point, which is what was Justice Cincinnati to do? My friend has made much of the fact that the affidavit was filed out of time, the affidavit of defense. It was filed out of time. So the first occasion the matter was called in court, leave to file your affidavit of defense. Second occasion it was called, further leave, and Justice Cincinnati on her own motion at that stage said, if you don't file it, I will award judgment. Now, there is a problem with that, because Justice Cincinnati, with great respect to her, could not have awarded final judgment. All that she could have done is said, I will not hear you on your defense, but I will hear your trial on the amount to be assessed as damages for breach of contract. So I will award an interlocutory judgment for default, and I will fix a trial date for you to prove your loss as a result of the breach of contract, for the plaintiff to prove his loss. The learned judge could not, without a hearing, have made an order for $99 million. It was without her jurisdiction under Order 4, Rule 6. All she could do is strike out or convert, and if she converted, treat it as a default proceeding and therefore fix a trial date. So the learned judge was wrong when she made what this, a rather draconian order in the circumstances. But, Your Honor, more than that, when the matter was next called on the commercial list before Her Honor, the affidavit of defense was there. It would have been absolutely easy, and in fact, in the usual course of things, that's what would have done, for Her Honor to simply have said, I have the affidavit, although it's out of time, I deem it properly filed, move on. Your Honor, I believe that Justice Cincinnati, when armed with that affidavit of defense, realized the problems which faced her on the face of the statement of claim. Because that affidavit of defense did two things. First,
Sorry, before
defense,
you go into that, counsel, just a point of information. The concept of judgment for damages to be assessed, does that exist under your rules or in your practice?
Your Honor, it does if there is summary judgment in default. In my experience, it has never been done this way, but I believe that the judge would have had jurisdiction at the time to say, I am not going to allow you further leave to file an affidavit of defense, but I will fix a hearing date.
No, sorry, but what I want to get clear is the concept of judgment for the plaintiff for damages to be assessed. I'm just seeking information.
Only, Your Honor, it has never been done in my experience. I have never been involved in such a case where a bail court or a commercial court judge faced with a list of specially endorsed writs makes such an order. But jurisdictionally, it is my belief on the old rules that a judge did have jurisdiction in a default situation, to grant summary judgment pending a hearing on the amount of damages to be awarded. So
Okay.
a trial on that question.
Okay, thanks.
Of course, that is not what was done here, Your Honor. So when the matter came back to the learned Justice Cincinnati, she was now armed with the affidavit of defense, which identified a number of things which were not before her before. First, the affidavit of defense pointed out that there's a written agreement between these parties. The statement of claimant didn't speak to a written agreement. The terms of the written agreement were not as reflected in the statement of claim. Second, the affidavit of defense pointed out that it wasn't just $60 million paid as an advance to this gentleman, this plaintiff, but two further sums were paid. I believe it was 40 and 30. But two further sums were paid, and your record will reflect that checks are attached to the affidavit of defense showing those sums being paid. So, although the statement of claim admits $60 million, in fact more than $60 million was advanced, changing the very simple maths on a very simple contractual situation. And finally, the affidavit of defense pointed out that this was not a specially endorsed writ matter. This was not capable of being heard and determined in summary proceedings by specially endorsed writ. And therefore I suspect that Justice Cincinnati paused. And then the question arises, what power did Justice Cincinnati have? With respect, I'd like to refer Your Honors, please, to Order 12 of the old rules which were before Justice Cincinnati. Those are the commercial rules which were introduced in 2006. Now, Your Honor, I'm aware that's not on the record. I wonder if Your Honors have a copy of those rules.
Yes, we do.
I'm very relieved to hear that.
And next time, I'm sure you will ensure that that oversight does not haunt you.
Oh, I'll give him an extension of time.
Yes.
Thank you, sir. If I can refer you, please, to Rule 4 that speaks to this unless order. It's at page 11, please. Where a party has failed to comply with any order of court, in respect to which no sanction for non-compliance is be imposed, any other party may apply to the court for, and the expression is in quotations, an unless order. Are Your Honors with me?
Yes.
Thank you very much. So please allow me to make the observation that this unless order doesn't happen magically. You apply for it. You file a summons asking the court to make an unless order. And paragraph 2...
Sorry, Counsel.
says that-
Are you suggesting that a court can make an unless order only if applied for?
Under Rule 4, yes.
No. I'm
court
not,
can make any
I'm not
provisions, sir.
asking. That's exactly my point. Under Rule 4, you apply for it. It's a different question I'm asking you. Can a court make an unless order if it is not applied for?
A court can make an order that has the same terms.
Okay.
If you don't comply, I will strike you out.
Okay.
But, Your Honor, it will not be an unless order within the definition of Rule 4.
Okay.
Subparagraph 2 of Rule 4 says what the applicant needs to show. His affidavit in support of his application needs to tell the court the order which has not been complied with, the nature of the breach, certifying that there is a default. So Rule 4 is very strict on the procedure by which you obtain an unless order. And I use the expression unless order as defined and identified in Rule 4 in quotation marks. You see, Your Honor, I am very leery of the possibility that any time a judge makes an order saying, if you don't do this, we'll strike you out, we call it an unless order. Because an unless order has specific definitions and a specific procedure under Rule 4. And if that procedure is not followed, it cannot be a Rule 4 unless order. It's some other kind of order.
It could be an order under Rule 7, couldn't it? Where you specify
Thank
the
you very much,
consequence.
Justice Hayton. That is exactly my view. And if I can refer you, please, to the opening paragraph of Rule 7, 7.1, where the court or judge makes an order, the court shall, whenever practicable, specify the consequences of failure. Now, Your Honor, that would be verbiage if we were treating Justice Cincinnati's order as an unless order under Order 4. Because an unless order, by definition, has intrinsically and necessarily in its characteristic that it tells you what happens if you don't comply. You are struck out. So it is clear that when Order 7 says if you make an order, you should, if you can, say the consequences. This isn't an unless order they're talking about. This is some other kind of order. Because it would be unnecessary to say this. It would be unnecessary to give the judge the admonition, say the consequences, if it was already an unless order. Because by its definition, an unless order has the consequences in it. This is another kind of order. Therefore, the procedure for the Rule 4 unless order is very specific and very different. If you want an unless order against me, you got to tell me. You have to file a summons, you have to say what the background is, and you have to, by separate interlocutory proceedings, begin this process for the unless order. If I can refer you, please, to subparagraph 5 of Rule 4. Subparagraph 5 of Rule 4 says that the unless order, and please notice the quotation marks, Your Honor. This is a special species of order we're talking about. A special Rule 4 created statutory species of order. An unless order shall identify the breach and require the party in default to remedy the breach by a specified date. So the unless order doesn't just say if you don't file this thing, you're struck out. The unless order is applied for specifically by an affidavit that must have specific contents, and on its face must say to you, this is the nature of your breach, you are required to fix the breach, and if you do not, you are struck out. None of that pertains to Justice Insinali's order. Justice Insinali's order is not made under Rule 4, it is not an unless order. Now that is very important, please, Your Honors, because the stringencies which the rules impose for setting aside or fixing default where there's an unless order are very different. Those stringencies are set out in Rule 6. You cannot make your application to set it aside more than 14 days after the judgment has been served on you. You cannot make the application to set aside more than 14 days after the judgment has been served on you. A door is closed. Your Honors, I've been struggling, I've been grappling with the rationale for this very clear procedure, which I believe is mandatory. Why do you have to file a summons? Why do you have to put all of this in your affidavit? And why does the unless order have to contain all of these terms in telling you what the breach is? Why is it that the rules contemplate separate interlocutory proceedings by way of summons with affidavit to get this unless order? And Your Honors, I believe, and this is not in my submissions, but I want to respectfully submit that the reason for that is because when you file your interlocutory summons and the unless order is made, that order can be appealed. It can be appealed to the full court. Whereas an order made by a judge in the course of trial, as you know, one of many of the administrative orders made, are not appealable to the full court independently, but form part of the appeal when the final judgment is pronounced upon to the Court of Appeal. And I believe that the draconian effect of the unless order necessarily contemplated not just that you have 14 days to set it aside under Rule 6, but that it forms a separate interlocutory proceeding commenced by summons, so that if I feel aggrieved by the unless order, I can appeal to the full court. I think that is why those precautions were taken as to the procedure. But Your Honor, that is thrown out apropos. If I'm correct, if the court agrees with me that what Justice Insinali did was not issue an unless order, but issue an order under Rule 7, then there are very different permutations. Because if the order is under Rule 7, then Justice Insinali was quite entitled under Rule 7 to say, if you don't file your affidavit of defense, I'll grant judgment. Procedurally, that was an entitlement given to her by Rule 7. But in that case, the defaulting party would have relief from Justice Insinali's order by virtue of Rule 8. So if I can go very quickly, please, Your Honor, through Rule 7. Rule 7.3 says where an order requires a party to do something and specifies the consequences of the failure, the time for doing that act may not be extended by agreement between the parties. But in Rule 8, Parliament decreed that an application for relief from any sanction, and that is the sanction imposed by Rule 7, please. An application for relief from any sanction imposed for failure to comply with the order shall be made promptly, supported by affidavit, and the judge will grant the relief only if satisfied A, B, and C are in existence. Your Honors, the application by way of summons by GRDB to Justice Insinali for an extension of time and to deem the affidavit of defense properly filed was an application which could properly be entertained by Justice Cincinnati as having been made under Rule 8. And that, please, is the gravamen of this appeal and the gravamen of everything that has gone below. If this court agrees that Justice Cincinnati's order was not an unless order under Rule 4, but it was an order which imposed the sanction under Rule 7, and Your Honor, with great respect, I believe there's no other possible conclusion, then Rule 8 kicks in when GRDB belatedly and through error of counsel and with a litany of errors comes to the court to say, we filed the affidavit of defense, we're late, we're sorry, please deem it properly filed. And the question arises, is that application for the extension of time and to deem it properly filed, can it properly be treated as an application for relief from sanctions? Because on the face of that summons, GRDB did not say, please give us relief from the sanction imposed by your order. GRDB just said, give us more time to file. Please deem what was filed out of time properly filed. And this, please, Your Honors, is where the very important decision by the House of Lords in Attorney General and I'm sorry, Your Honors, I'm buried in paperwork.
So are we?
Universal project, isn't that you're speaking of?
Yes, please, Your
Another
Honor.
matter.
The Attorney General and Universal Projects. 2011 UKPC, page 37. I refer to it, please, at page 372 of your record. Now, Attorney General and Universal Projects, I believe, is definitive for the purposes of this case. In Universal Projects, an order was made that if you don't file within a period of time, we strike you out. And the Attorney General applied for an extension of time, not for relief from sanctions. So, what happened in the case at bar, what happened in the case before, Your Honors, happened in Universal Projects. And it was argued that there was no application for relief from sanctions, and therefore the Attorney General was in trouble. But Justice Gobin at first instance decided that there's no magic in this expression, relief from sanctions. Your application doesn't have to verbatim say, please for relief from sanctions. If your application says, please give me more time, or please deem this affidavit properly filed, implied in that, of course, is an application for relief from the sanctions previously ordered. And therefore, Justice Gobin, with great respect to her, quite properly, treated the application before her for the extension of time as if it was an application for relief from sanctions under the Trinidadian rules, which were in pari materia with the now obsolete rules in Guyana. She treated that application as if it was an application for relief from sanctions. And if I can refer you, please, to paragraph 7 of my submissions at page 373 of the record. The Privy Council concluded that Justice Gobin had acted correctly. The Privy Council said at paragraph 16 of its decision, the board has concluded that the application to set aside the default judgment was an application for relief from sanctions within the meaning of the Trini rule. Because, of course, you cannot give an extension of time unless you've given relief from the sanctions in the previous order. It is necessary corollary. And what the Privy Council said, and curiously enough, the full court, in this case, the full court of Guyana, quoted Universal Projects and quoted the Privy Council and quoted what the Privy Council said, that there's no magic expression, relief from sanctions. There's nothing magical in those words. So that when you apply for an extension of time, or when you apply to deem the document properly filed, implied in your application is an application for relief from sanctions. Ironically, the full court read that, it quoted that in its judgment, and yet it came to the conclusion that Justice Cincinnati had no jurisdiction to treat the summons before her as an application for relief from sanctions. And the entire decision of the full court, interestingly, turns on the fact that there was no application before Justice Cincinnati for relief from sanctions. That is what the decision of the full court turns on.
Mr. Jonas, I think you have reached your 45 minutes. Do you need to speak much longer?
Your Honor, I'm always subject to your direction. Are you minded to hear me, or do you wish me to stop?
No, but just give me an indication how much more time you need. Maybe
15 minutes, please, sir.
Isn't that overreaching, Mr. Jonas?
I will speak quickly, sir. 10 minutes.
Okay, about 10 minutes, but that should be it. I think you have been quite elaborate, so maybe you can, I think you already touched the main point, so please continue, but keep it as short as you can.
I certainly will, sir, and I apologize for that. If this court agrees that what was before Justice Cincinnati can be treated in the spirit of Universal Projects as an application for relief from sanctions, then the full court is wrong, because the full court ignored that point entirely and completely misconstrued the decision of the Privy Council. So we are now at the Court of Appeal.
But sorry,
And
Counsel, in relation to that part of your submission, what has engaged me is that Justice Cincinnati has stated specifically that there has been no application for relief from sanction and no reason has been given why there has not been such an application. It seems to me, therefore, that she adverted to the existence of that power and she determined that she would not exercise that power because there had been no such application.
If you please, sir, Justice Cincinnati reached the exact conclusion that Justice Gobin reached in Universal Projects, but she reached it by a road which was erroneous. So we are back to the same situation where, as Your Honor pointed out with Justice Gregory in the Court of Appeal, she reached the correct conclusion, in my respectful view, granting the extension of time, but she did not include all the parameters. Justice Cincinnati reached the correct conclusion, but she erroneously failed to understand that what was before her impliedly was an application for relief from sanctions. Justice Gobin, faced with the same application, understood that. So, Your Honors, we are back to the situation where Justice Cincinnati acted with jurisdiction that she had, but with great respect to Justice Cincinnati, she did not appreciate how she had that jurisdiction. So she reached the correct conclusion, and this court, if it finds she reached the correct conclusion, can permit that conclusion to stand.
What makes it the correct conclusion?
That she had jurisdiction to revisit her order that was made that included the sanction that if you do not file within a time, we will grant judgment. She had jurisdiction to revisit that order under Rule 8.
With respect, Counsel, that's not what she decided.
No, it's not.
That is specifically not what she decided.
I agree with you, sir.
She decided that she has the inherent jurisdiction to recall the order which she made, as opposed to relieving a party from the sanctions because they have satisfied the three mandatory criteria.
I agree with you, sir.
Well, thank you. I'm flattered.
Which is why, sir, I have to contend respectfully that Justice Cincinnati's conclusion was correct. She had jurisdiction. She had jurisdiction because her first order was made under Rule 7, and therefore Rule 8 permitted an application for relief from sanctions, and the summons that was before her, in the spirit of what was before Justice Gobin in Universal Projects, was an application for release from sanctions. She went down the wrong road to reach the right destination. And this court, I believe, has the power, when it considers what was done and considers the interest of justice and whether she did have jurisdiction, this court can conclude Justice Cincinnati reached the right conclusion. She did have the jurisdiction, but she was incorrect in trying to rely on a jurisdiction other than that given by Rule 8. I think that this court can and properly should arrive at that conclusion in the interest of the justice that Justice Cincinnati was trying to achieve and did achieve. She acted with jurisdiction. She just misunderstood where her jurisdiction came from. And that does not mean she did not have jurisdiction, sir. That's a very big difference.
I must say the words erroneous and error are abundant in this particular case. Did you hear what I said?
I did, sir.
Yes.
And it is true of the bench and the bar in this case. It is unfortunate.
Okay, continue.
The question then arises, if this court agrees that the full court was wrong to say that Justice Cincinnati did not have an application for relief from sanctions before her, and if this court concludes that the full court erred when it said Justice Cincinnati had absolutely no jurisdiction because Justice Gobin had jurisdiction and therefore Justice Cincinnati had jurisdiction. If this court comes to that conclusion, then what we have is a miscarriage of justice, because we have a statement of claim that is hopeless, we have maths that is completely untenable, we have an affidavit of defense filed out of time but which raises facts to show that the judgment is unsafe if awarded. We then have a judgment by the full court that it could not make because there was no trial to assess the damages as a result of the breach of contract. And therefore the question is, did the Court of Appeal properly exercise its discretion in the face of all of this to say, look, we got to fix this thing, we give leave to appeal? This court will have to find, once this court agrees with me, and I believe the court has already expressed an opinion, that jurisdictionally the Court of Appeal could have granted an extension of time. Once this court agrees that the Court of Appeal had the jurisdiction, then this court will have to say that the Court of Appeal exercised its discretion on a wrong principle of law. And Your Honors, this court has consistently said, when you see a miscarriage of justice or you see an unsafe judgment, fix it. Don't worry with errors of counsel. Don't worry with delays. Don't worry with all of those other factors that Your Honors have already pointed out are also relevant and are raised by Justice Gregory. Fix the miscarriage of justice. That is what I rely on, please, Your Honor.
I don't
$99 million.
recall any judgment where we put it in this way, but could you give us a judgment which comes close to the formulation that you just used?
Yes, please, sir. Mohan and Prasad. Justice of Appeal Nelson, it is at page 366 of the record in my submissions.
Yes.
In Mitchell, President Court Justice of Appeal Byron quotes Blackmun and Gittins and Blackmun and says that where this court held that while in the absence of an application for an extension of time, there wasn't even an application. It had no jurisdiction to entertain the special leave application. The court may, in a proper case, grant an extension of time for compliance with the rules or excuse delay to avert a clear miscarriage of justice. This court can sweep it all away. And again in Mohan and Prasad, cited at paragraph 6 of that page, the litany of problems that happened in the courts below were not the end of the matter, because it is possible for the CCJ in a proper case to hear an application for special leave in the exercise of the court's broad jurisdiction under Section 8, Section 8 reserves an unlimited residual discretion to prevent miscarriages of justice. The public interest in the swift administration of justice is of great importance, but the length of and reasons for the delay should be weighed against the possible merits of the appeal. Therefore, despite the absence of any plausible explanation for the delay, no plausible explanation, error of counsel ad nauseum, the Court of Appeal should have proceeded to assess whether and to what extent refusal of an extension of time might result in a miscarriage of justice. This court, sir, disagreed with the Court of Appeal refusing an extension of time, even though there was a myriad of delay and unforgivable error of counsel, because on the facts of that, the judgment awarded was for one sum, and it appeared from the record it should have been for another sum. Your Honor, there is not a large divide between those facts and these.
Yes, I just make the point that in Mohan, the court referred, among others, to Guyana and others, and Harney and others, from the Eastern Caribbean Court of Appeal, and that is actually referred to in the judgment of the Court of Appeal, and it ends by saying, on the other hand, if there were no substantial reasons to justify an inordinate delay, but prima facie there appeared to be some merit in the proposed appeal, the application should be granted. But I thought, I remember that our court said, well, we wouldn't go that far, that there needs to be some merit. It needs to be a little stronger than that.
Your Honor, I can't imagine anything stronger than a $99 million.
Well, you're saying there's not some merit in this case, there's a lot of merit in it. Is that what you're saying?
Your Honor, I'm saying that this plaintiff would be faced with a brick wall if he had to argue this on the merits.
Okay. That concludes your submissions.
I hope I stayed within the 10 minutes. Thank you very much.
Thank you. Mr. Nambla, you have some time for a reply if you wish.
Thank you, Your Honor. Your Honors, I wish to begin from the top, and I reiterate that respectfully that the Court of Appeal did not invoke Order 1, Rule 8, that the Court of Appeal stated the rules upon which it predicated the exercise of its discretion. So there is no need to speculate. And that those rules deal with an extension of time to appeal, and they are completely irrelevant to this application, which was an application for an extension of time to seek leave to appeal out of time. And that the orders of the Court of Appeal were orders that were absolutely wrong, if not irregular. And that Order 1, Rule 8 was not at all referred to by the Court of Appeal, and I invite this Court not to speculate, because the Court itself stated the orders that it relied on. Then, Your Honors, no leave, no extension of time was granted for leave.
In that respect, Mr. Nandlau, if that may be corrected perhaps under the slip rule, because when you look at the Court of Appeal judgment, at the end of paragraph 23, the Court of Appeal states, thus on the face of the proceedings, and having regard to the available material, we do not find that the respondent will suffer a miscarriage of justice if leave to appeal out of time is granted. we feel that the important procedural issue involved is also an exceptional circumstance justifying the extension of time to appeal. Thus, they decided they were going to grant extension of time to appeal, although in their conclusion and in the order that you cited earlier, they just actually granted leave to appeal within 7 days. So I would imagine the order of the court can be amended under slip rule, when they very clearly expressly stated in their judgment that this was a case justifying the extension of time to appeal.
But, Your Honor, I still maintain respectfully that they had no power to grant an extension of that 14 days which is required.
Okay, we note that.
Leave. The other point, Your Honor, that I wish to make is that none of the mathematical errors or what have been described as mathematical errors have been raised in the court below. Your Honors, in my written submissions, I cited a rule, Order 53, which in essence says that non-compliance with Order 54, non-compliance with any of the rules is a mere irregularity, and it sets out a procedure by which one must register an objection if one is contending that there is some irregularity or non-compliance. A summons has to be filed, and in that summons, the particular complaint specifying the non-compliance has to be set out. If one does not adopt that procedure and one takes a fresh step after whatever deficiencies may be on the record, then one is taken to have waived it. So I wish to put that forward and to submit respectfully, and Your Honors can look at the record, and Your Honors will agree with me, I have no doubt, that all the multiplicity of mathematical errors which have been identified here are nowhere on the record. They have been raised here for the very first time. The only thing that is on the record which may lend some support to the arguments which we have heard here today is the affidavit of defense, which was never really put on the record because, and we never got an opportunity to respond to it, because when it was belatedly accepted, the full court granted judgment and obviously necessarily had to set it aside, which never gave us, the plaintiff's lawyer, an opportunity anywhere to answer it. And in the proceedings in the Court of Appeal, they were not raised again. So there was never an opportunity again to respond to them. Your Honors, in relation to Justice Insanali's order, I respectfully ask the court to adopt the position articulated by Justice Barrow. His Honor identified correctly the ratio decidendi of Justice Insanali's decision. My learned friend would like to put a whole set of other reasons why the judge decided why the judge did. But the judge's reasons are very clear, and they are stated there. The judge felt that the judge had the power, an inherent power, he described it as, to recall what the judge described as an unless order. The judge felt that the judge granted an unless order. The registrar felt so because the registrar entered the order. There was never an application for relief from sanction, so there was nothing in the Privy Council matter emanating out of Trinidad. Justice Gobin expressly treated that application before her as an application for relief from sanction. In these proceedings, Insanali J never did so. Never did so. Insanali J simply recalled what she persuaded herself and felt was an unless order, and proceeded to grant leave to file an affidavit of defense. The full court, and that is what the full court was invited to review. It would be unfair now to import different and extraneous considerations that were not before the full court. And fault the full court for not taking matters into account which were not canvassed before the full court. The narrow issue before the full court was whether Justice Insanali acted properly when Justice Insanali exercised her alleged inherent power and recalled an unless order. That was the narrow issue. And the full court said that they could not have done so. No one pointed out all the arithmetic alleged errors to the full court. Lawyers were present. And therefore, the full court, having the power that the High Court has, granted judgment. At that point in time, arguments could have been so the full court did not have to grant judgment. The full court could have set aside Justice Insanali's order and gave proper directions. Were the appropriate submissions made that would have alerted the full court or invited the full court to consider whatever inaccuracies it is now complained that inhere in the statement of claim. No such representations were made to the full court.
He argued as an
Right. So I was just fact checking whether the GRDB was not represented at the full court, and they were. And none of these arguments, which could have, if they were adjudicated upon and both sides could have had a different course. But the respondent stood silently by and judgment was granted. Then we move to the Court of Appeal. And I invite your honors to look again at the record that was before the Court of Appeal.
Mr.
And you
Nandal,
will not see.
Mr. Nandal, you filled your 10 minutes. You want an extension of that time?
3 minutes, Your Honor.
3 minutes, okay, fine.
Yes. And your honors will not see all the arithmetic errors complained of, etc., etc. So, your honors, in conclusion, I will respectfully ask that this court set aside the decision of the Court of Appeal granting the appellant leave to appeal and leave to appeal out of time.
Thank you very much. Okay, gentlemen, we have heard your arguments, and we will study and discuss them. And when we have reached a decision, you will be notified.
Thank you very much, Your Honor.
Thank you
Thank you.
both very much.
Court rise.